Okay, good morning. I think I am going to use this. Hello? Is that working? Okay, great. I'm going to use this. I have the pleasure of having the opportunity to speak with you this morning, and then I have a short session this afternoon. Appleseed's celebrating our 15th anniversary with a banquet in Omaha tonight, so I have a speaking part of that, and then we're in Ashland tomorrow. So I think if I don't use this microphone, I might not have a voice by the end of the day tomorrow. So thanks, it's great to be here in Norfolk. My task for this morning session is to go through some of the key pieces of juvenile case law that has gone up through the Nebraska appellate courts over the last year, and also some key pieces of legislation that have been passed by the Nebraska legislature. In about 30 minutes, but I guess now I have a little bit more than that. But that's sort of a tall order. So what I've done to kind of break that down is I'm going to be talking about, I think, 6 or 7 key cases from the Nebraska appellate courts, and then I'm going to be talking about key pieces of legislation that passed. In your handouts or in your packets, you have case summaries from the Through the Eyes of the Child initiative. I think those summaries include pretty much all of the juvenile cases that came down in the past year or so, including cases that I'm not going to discuss today, so just know that you have that as a reference for the cases that I'm not going to discuss. There's also a chart from Appleseed that has our little tree logo on it. It is all of the pieces of child welfare legislation that Appleseed monitored over the course of the past year, and then the final actions at the end of the session on those bills. So you can also reference that for some of the bills that I won't be talking about this morning in the presentation. So with that, we'll jump right into it. This first case today, Leland B., was not the first case to say it, but clearly held that incarceration alone cannot be the sole basis for a termination of parental rights. And the background of this case is that Leland entered foster care after his mother was unable to care for him due to a mental health issue. The father was incarcerated on a drug issue. The mother passed away about a year later, and the father was contacted by the department. At that time, the father had asked for Leland to be placed with, I think, the father's sister. Leland remained in foster care. The state filed an adjudication petition based on the father's incarceration. The father admitted to those allegations, and then eventually the state filed a motion to terminate the father's parental rights on the basis that the father had neglected Leland by not providing him with necessary parental care and protection. The juvenile court terminated his parental rights, and the father appealed. At the termination hearing, the caseworker testified that Leland had a relationship with the foster parents, had improved in that setting, and raised some concerns about uncertainty regarding the father's housing and employment following his release from incarceration, and also questions about his ability to parent because of the time that he had been incarcerated. The Court of Appeals concluded, however, that all of this evidence was anchored, is a term that the court used, on the father's incarceration and could not be a basis for the termination of parental rights. The Court of Appeals noted some facts, I think, in support of the father, that he had been the primary parent prior to incarceration. He had seen the child on a nearly daily basis, that he had stayed in contact with HHS and the child through letters during the course of the case, that he desired to parent Leland, that he had taken parenting and substance abuse classes during his incarceration, and that he had presented a plan for how to regain custody and housing and employment following his release. And so the Court of Appeals concluded that the father should have the opportunity to work a reunification plan upon his release and overturn the termination of parental rights. Okay. This next one is interesting in that it talks about the juvenile court's broad subject matter jurisdiction over juvenile cases involving any child, regardless of their temporary residence in another county, and how the issue of venue is best handled in that scenario. In this case, the child sort of went back and forth between the mother's home and the grandmother's home. The mother had substance abuse issues, and so whenever the grandmother would report the mother to the authorities, the mother would take the child back. Eventually, the child was removed from the mother's home. The state filed a petition at the time in Douglas County. At the time of the filing of the petition, the child was residing with a grandmother in Cass County. And at the protective custody hearing, both the mother and the father argued that the court lacked personal jurisdiction over Brianna and that Douglas County was not the proper venue. The juvenile court granted the motion to dismiss and the state appealed. In reversing the juvenile court's dismissal, the Court of Appeals first clarified that this was actually looking at subject matter jurisdiction, which is the court's authority to hear certain actions. And under the Juvenile Code, the Court of Appeals indicated the juvenile court has far-reaching subject matter jurisdiction under 43-247-3A over any juvenile who lacks proper parental care, regardless of the child's temporary residence in another county. And that this is, read this as broad subject matter jurisdiction. As to venue, the court noted that the proper venue is immaterial to whether a child falls within the meaning of 43-247, and that a separate statute, 43-282, gives the court discretion after adjudication to transfer a case to the county where the child's residing, and so noted that the proper procedure, the juvenile court shouldn't grant a motion to dismiss on the basis of venue, but first hold an adjudication hearing, and after that point, to hear the matter of transferring the proceeding to another county. Okay, this one's an unpublished case, but I included it in my top 6 or 7 because I think it has an interesting analysis of the court's approval of a case plan. This case involved a 12-year-old girl who was removed from her mother's home due to allegations of physical abuse. The juvenile court adjudicated and ordered the child to remain in care with placement to include the father's home, and the mother appealed. On appeal, the Court of Appeals affirmed the adjudication but reversed as to continued placement with the father, finding that the mother had overcome the presumption in statute at that time that the department's plan for her to reside with that it was in her best interest to reside with a father had been overcome. The evidence presented by the mother included a home study in the state of Ohio, indicating that the father had had a history of domestic violence, an arrest, a violent history, and that the child, or that the father and the father's wife were physically disciplining the child, that the child didn't wish to reside there. The Court of Appeals noted that 43-285 is the applicable standard in reviewing the state's plan for the placement of the child. And then in dicta, the Court of Appeals noted that a recently passed piece of legislation that I'll talk about at the end of this session eliminated that presumption in statute that the department's case plan is in the child's best interest. But at the time of this case, that presumption was still in existence in statute, but found that the mother had overcome that by the evidence that she presented. Okay, this is also an unpublished case, so there are 2, but this one's on reasonable efforts, and I think that's always helpful for us to get a better understanding of how reasonable efforts operates. In this case, 3 children were removed and placed in foster care due to exposure between the mother and her boyfriend and neglect. Over the course of a couple of review hearings, the juvenile court ordered visitation and then placement with the children's father. 2 children with one father, and then the third child had a different father. Both were out-of-state placements. The juvenile court also held that reasonable efforts had been made and that the permanency plan was reunification with a mother with a concurrent plan of adoption. The mother appealed on the basis that placing the children outside of the state of Nebraska made reunification with her a practical impossibility. The Court of Appeals affirmed the placement changes, and in doing so distinguished a previous case in re interest of Ethan M., in which a child placed with a non-custodial mother in California was overturned, and the court was directed to approve placement in a home that was more conducive to reunification, in that case with a custodial father in Nebraska, because reasonable efforts to reunify in that case had not occurred. There was an aggravated circumstances exception, and then that was, I think, also overturned on appeal in that case. In this case, in Corey W., the court distinguished this situation. The child had been in out-of-home care for 14 months, and the mother had been provided, the court found, with services during that time and hadn't progressed enough to the point of reunification. And so the Court of Appeals rejected the mother's argument that Ethan M. created a hard and fast rule against out-of-state placement with a natural parent, where there's a goal of reunification with the natural parent. And the distinguishing factor seems to be whether reasonable efforts have had an opportunity to be made prior to that point. The Court of Appeals also noted the presumption in favor of placement with a biological parent in other case law. And then finally, sort of as a technical note, the Court of Appeals noted that the concurrent goal of adoption should be changed to change of custody in a situation if placement with another non-custodial parent occurs. Okay, this case went up and up all year, Court of Appeals and then Supreme Court. Ultimately, the Nebraska Supreme Court reversed the decision of the Court of Appeals, which held that the aggravated circumstances exception to the reasonable efforts requirement does not apply in ICWA cases. The Supreme Court reversed because the appellant father did not timely file his notice of appeal, and therefore the appellate court didn't have jurisdiction. The Supreme Court, however, did go on to consider the father's assignments of error with regard to the termination of parental rights, because that notice of appeal was timely filed, and upheld the termination on the basis of evidence primarily that the parents had caused shaken baby syndrome. In looking, though, I just want to mention some practical implications of this case. I think it's important just to note that the Supreme Court reversed the Court of Appeals decision as to the aggravated circumstances question based on a jurisdictional issue. So while the Court of Appeals decision is not binding case law, you could speculate that if a case properly came before the Court of Appeals, they may have a similar analysis of that issue. So I just want to go through that. In non-ICWA cases, just to clarify, the state can be excused from providing reasonable efforts if a court of competent jurisdiction finds an aggravated circumstances is present, such as abandonment, torture, chronic abuse, the rights to a sibling have been terminated. However, for the active efforts requirement of ICWA, the heightened requirement in ICWA, reasonable efforts requirement in ICWA cases, the federal law, the Court of Appeals found applies to all cases involving Indian children, and that court held that the 43-283-01 regarding aggravated circumstances does not extend to ICWA cases or trump the specific requirements regarding active efforts in federal law. So again, that's not binding precedent, but that was sort of the issue in case it would happen to go up again. Okay, this one is hot off the presses. This case came down, I just added it in here, this past Friday from the Nebraska Supreme Court. Appleseed filed an amicus brief in this case, and so we think that this set an important precedent, and that is that juvenile courts in Nebraska do have the authority to hold the department in contempt for failure to comply with an order of the court. And to give a little bit of a background on this case, if you haven't had a chance to look at it, this case involved two orders regarding a juvenile that was originally a 3B case and then was adjudicated as a 3C. The child was placed in detention and had lingered there for, I think, about 3 months. At a dispositional hearing, the juvenile court ordered, among other things, that Thomas receive counseling at least 3 times per week while he was in detention, and that the department arranged for that counseling. About 2 weeks later, at another dispositional hearing, the juvenile court directed the department to provide a list of appropriate placements. Following that hearing, the juvenile court stated in an order that if no appropriate placement was immediately available and presented to the court at a placement hearing scheduled for the next week, then HHS would be in contempt and ordered to pay a fine of $400 per day until the child was appropriately placed. At that placement hearing, a week later, the juvenile court in fact found HHS in contempt and ordered HHS to pay $400 per day on the basis that the child was not receiving counseling as ordered and therefore was not in an appropriate placement. Also at that hearing, they had identified a new placement in that placement, a group home, and that was approved as a proposed placement as soon as the bed became available. HHS appealed the first order, alleging that the juvenile court did not have the authority to hold the department in contempt, and that sovereign immunity, which is a constitutional limit on lawsuits against the state, barred a finding of contempt against the department. On the first issue, the court first determined that the issue was moot because the HHS got counseling in place pretty much immediately after that hearing and never paid the $400. But the Supreme Court went on to consider the issue under the public interest exception to the mootness doctrine, which allows an appellate court to review an issue of public interest on which authoritative guidance is helpful when that issue has evaded review or has the potential to evade review. And this issue had been before the appellate courts a couple of times and never squarely was before the court for decision. And so in considering it, again, the Supreme Court held that juvenile courts in Nebraska do have the authority to hold the department in contempt. That authority is statutory. It's found in 25-2121, which is the general contempt statute that indicates that any court of record has the power to punish by fine or contempt, fine or imprisonment for contempt, and that juvenile courts are courts of record. The Supreme Court also determined that the state had waived sovereign immunity by initiating action through the county attorney and by appearing in the case. However, the Supreme Court in this case determined that HHS did not have sufficient notice and an opportunity to be heard, in that as to notice, the written order did not specify clearly what constituted an appropriate placement, and I think the Supreme Court didn't think it was clear that failure to arrange counseling 3 times per week would constitute an inappropriate placement or would constitute contempt. And specifically, the court noted that there was no order to show cause order specifying that the counseling component of the placement was critical to the juvenile court's assent to that placement and would result in contempt. And the Supreme Court cited a case noting the importance of an order to show cause prior to holding a party in contempt. The Supreme Court also determined that the record didn't show that HHS had a meaningful opportunity to show that the department's noncompliance was willful. The department raised this as a due process issue, essentially, and the Supreme Court said that the department isn't a person and therefore can invoke constitutional protections, but agreed with the department that notice and an opportunity to be heard are an important component of a contempt order, and held that in order to find a party in contempt, the juvenile court must make a finding that the violation of the order was willful. And then finally, there was a second order in the case requiring the court to provide the court and the parties with proof of payment associated with the child, proof of payment for the child's new placement in the group home within 20 days or face contempt and a fine of $500 per day. And the department argued that that order interfered with their right to contract. The right to contract argument was essentially that order violated the department's right to contract because it threatened to hold the department in contempt for one of its contractors' lack of payment. The facts of the case don't go into a lot of detail, but the record, this order was, I think, in September of 2010. This is a Cheyenne County case, so it was at the time when, just prior to when Boys and Girls Home terminated their contract and weren't able to pay some bills in a timely manner. And so there were concerns about failure to pay for the placement would threaten that placement that had been looked for long and hard. HHS had not yet been found in contempt on that issue either, so the court reviewed it but limited its review to the terms of the order. The Supreme Court recognized that the department has a technical right to enter into contracts and has a responsibility to pay its obligations, and cited 43-290, indicating that when a child is placed in the care and custody of the department, that the department shall pay for the support, study, and treatment of the juvenile, but rejected the department's argument that the order interfered with their right to contract and therefore didn't affect a substantial right and wasn't an appealable order. And so dismiss the case on that basis, on that assignment of error. Great. Okay, so, this is my little trick. I was gonna ask if anyone could guess what the number one biggest case of the year was, but I already showed you. The last but not least, I want to just talk about Camreta versus Green. I think that this is sort of an interesting case because it was a case that went before the United States Supreme Court this year, and it was sort of a widely anticipated case. Let me just grab my notes here. I'm on a couple of national listservs of child welfare attorneys, and they've been debating this case all year. But ultimately, this case was thrown out on a jurisdictional issue as well. But it involved a decision of the Ninth Circuit Court of Appeals, which held that the state must obtain a warrant before interviewing a suspected victim of child sexual abuse at school, or get the parents' permission. That didn't occur in this case, and that the failure to obtain a warrant violated the child's Fourth Amendment rights against search and seizure. As I indicated, the court didn't reach this issue. The United States Supreme Court didn't reach it because by the time it got all the way up to the highest court, the child had moved out of the jurisdiction, was about to reach the age of majority. So the United States Supreme Court said the likelihood of that harm recurring within the circuit was minimal, and so the case was moot. And so again, as with the Jemiah case, there's been a lot of discussion on these listservs about, even though the Ninth Circuit opinion is no longer binding precedent, if another case would come before the Ninth Circuit that was properly before it, would the Ninth Circuit rule the same, or how would other circuits rule? But again, this is still an open question. Okay, and these are just some honorable mentions, some other cases I want to mention. But I won't go into detail in the interest of time. Okay, turning over to the legislative branch of government. This was I would say, busy and productive session at the legislature. Just gonna kind of put them all up there. I'll talk about LR 37 shortly. These are bills that all passed the legislature this past session. LB 80 is the one that I mentioned previously. That is a bill that eliminated the presumption in 43-285 that the HHS case plan is in the child's best interest. So if you recall that statute, the presumption is not explicitly in statute. It basically says if any other party other than the department proves by a preponderance of the evidence that the state's plan is not in the child's best interest, the court shall disprove the case plan. That language was essentially stricken from the statute. So now all parties are essentially on a level playing field, so to speak, and I think the hope is that this will encourage all parties to bring forward evidence of what's in the child's best interest in terms of development of the case plan. And LB 80 was attached to LB 648, and that bill made mandatory, it changed from a may to a shall, the juvenile court's inquiry into the well-being of the foster child to any foster parent, pre-adoptive or relative placement that's present at a hearing and willing to provide that input. And then it also strengthened some language to ensure that foster parents and relatives have notice of hearings. LB 94 also passed. That provides that petitioners for adoption of state wards are given an opportunity to review the child's case file maintained by the department, and that HHS shall provide for documentation that the parents have had an opportunity or been made aware of their opportunity to review the case file, and that HHS is to file that document to the court prior to the entry of a decree of adoption. And then finally, LB 177 is a new law that placed three key provisions of the Federal Fostering Connections to Success in Increasing Adoptions Act into Nebraska state statute. Those are provisions related to requiring notice to relatives within 30 days of the child's removal, so they could be considered as a potential placement. Reasonable efforts to place to make reasonable efforts to place siblings together or to provide for other ongoing contact when that's not contrary to the safety or well-being of the children. And then a provision regarding transition plans for youth transitioning out of care. I'm not going to go into detail on those because our afternoon session will have an opportunity to talk at least about the sibling and the transition plan provisions. And then at the bottom, also past this session, LB 112 provides an exemption to motor carrier regulations for youth care providers. This, I think, eliminates a lot of red tape and expense to enable private providers to have caseworkers and other staff that known to the child to transport children to services, and so we supported that because we think it's better to have someone that knows the child transporting the child. And then LB 124 provides that cultural history information, including the child's race, ethnicity, nationality, tribal affiliation, if any, be included in the medical histories required to be included in the court record if available following a petition of adoption. And then LB 79 created a fund for the statewide CASA program, and that was attached to LB 463, which is Senator Ashford's truancy bill. And then LB 479 allows 18-year-olds who are victims of sexual abuse or domestic violence to be examined and treated by a physician without consent of their parents or custodian. And LB 669, I believe, is a cleanup on last session's LB 800, which included provisions for the sealing of juvenile court records. Again, in your materials you have Appleseed's final actions chart, which provides a listing of the bills that we were monitoring. Note that this upcoming session is the second session, starting in January, the second session of the biennium. It's the short session, they call it. And so any bills that were not killed in committee or indefinitely postponed are still alive, so to speak. And so I want to note a couple of bills that are still held in committee. Those could be amended or could come out of committee this session. LB 199 regarding adequate payments to foster parents, and then LB 433 regarding oversight of child welfare contracts are both in committee, still in committee. And then LB 95, which sought a moratorium on further privatization in the central, northern, and western service areas, is pending under a motion to bracket following an agreement between the legislature and the governor to hold off on further privatization in your area until June of 2012. So that's under a motion to bracket at the present time. Any questions about any of that? Yeah.
I have a comment. The Through the Eyes initiative and also the judges were surveyed as part of LR 37. And I actually just got it's what made me think of it, I just got an email. Apparently I'm going to provide the results of those surveys to a hearing on October 18th. And at that time, I will send out the survey results to all of you. It's really for the LR 37, so I can't. But I will say that the judges survey, 85% of the judges with juvenile court jurisdiction responded, which is an incredibly high response rate. And, so what the judges said will sound like it'll be a very good indicator in terms of the judges' perceptions as to what's been going on. And I know Senator Campbell was both pleased and very pleased and surprised and impressed that that many judges completed the survey. So you'll know more in October 18th.
Yeah, I think that's great. So thanks to everybody for responding to that. And that's a perfect lead into my next comments in terms of upcoming legislative issues to watch. As Vicki said, LR 37 is the interim study that's currently underway. I'm sure you've participated or at least read about that. That allows the HHS committee of the legislature to investigate the child welfare reform and privatization, and there have been hearings across the state. Was there a hearing in this area yet? I know there's one coming up in, okay, good. Hopefully you had an opportunity, and then as Vicki mentioned, the surveys as well. And so I think it's fair to say that the legislature really wants to hear from everybody involved in the system. So those surveys and hearings are a great opportunity to do that. Also underway is a legislative performance audit. You may have heard the Legislative Performance Audit Committee of the legislature is also doing an audit. The focus of that is the reform, the Families Matter, and the specific issues they're looking at is whether the goals of the privatization have been implemented, whether the executive branch exceeded its authority in implementing reform without legislative involvement, how HHS and policymakers know if the privatization is working, and whether contract oversight is sufficient. That report is expected this fall. The LR37 committee, or the HHS committee as part of LR37, I believe will also have a final report, and that's expected later this year. So there's really a lot going on in terms of child welfare reform at the legislature. Appleseed does a lot of legislative work, and the rest of the programs, healthcare, low-income access, they're all feeling like it's there's a lot going on with child welfare, so that's taking a lot of attention, but there's a lot of good things happening in other areas as well. But there's really a lot to keep up with, and would encourage you to share your perspective. So, are there any questions? I should have stopped after the cases.